wanted to, just a quick note that the judge is going to decide the punishment. I think that was made clear to y'all, but I don't know if it was confusing here with the closing statement. So I guess I'll kind of address quickly the idea that I bowed to political pressure. There's no evidence in this case that I bowed to political pressure. And I think if you remember in the opening statements, the defense talked about all these third-party investigations that went on in the opening. And the easiest thing would have been me to do what all those did, which is say, don't blame us, blame somebody else, or everybody's to blame, therefore you can't hold anybody responsible. That would have been the easiest thing. So, you know, I've never bowed to political pressure. And that's not what this case is about. The defendant, in their opening statement, they talked to you about, and they did here in the closing, that he was not assigned to the school. He relayed information. He drove to the school. He went into the building. He called for SWAT. He stood perimeter. He evacuated students. He had no shields. He checked on another officer. He got the building plans. He secured a master key. And there was even testimony during the trial that he evacuated students, and wasn't that a good thing? A good thing. And he relayed information over the radio, and wasn't that a good thing? Ladies and gentlemen, this is not about doing a good thing. I am not standing in front of you, and this case has not been about handing out participation trophies. That's not what this case is about. This case is about, and it's always been about, holding officers to the duty that's mandated for them in the law. Mr. Turner and I, as prosecutors, we had these big books that we're supposed to follow, and the laws and all that, and he described to you that there's a special law in these books. One special law with regard to children. And that's what this case is about. All of this, the personal attacks, all of that was an attempt to justify the unjustifiable, in my mind. We're not talking about people being perfect. We're not talking about pretzels. And I'm not here to send mixed messages. I'm here to say that when you are a peace officer for a school district and you raise your right hand and say, I am going to be a peace officer, I'm going to do my job, that you're going to be held responsible. You're going to be held to that duty. You know, when we had the active shooter training that was brought in, that active shooter training goes through all the mass shootings of schools back to Columbine. At the time that the Robb shooting happened, we've had, 23 years of mass shootings. And school districts have begun their own law enforcement police force. That's saying, we're not just going to depend on the local police department, we're not going to depend on the sheriff's office. This school district, the Uvalde Independent School District, we are going to have our own police force. So what does that mean? That means these buildings, there are their homes. Those hallways, there are their roads. Those students in those classrooms, those are their people to protect. Even Mr. Gonzales, the defendant, says that in his video recorded statement to the Rangers. He says, it was a car wreck, but that's not my responsibility, that's the local PD's responsibility. But when I heard that there was a gunman and he was near the school and entering the school, that's when I got in and went. Because that's his jurisdiction. That school district. That's his jurisdiction. Those students are his people. The charge that you have talks about the legal duty that the law enforcement is supposed to be responsible for. And then it talks about the Texas Education Code. And that's because our legislature had mandated that. And we cannot turn a blind eye to that. You know, their own expert witness talked about being in San Antonio and how he went into hot situations. Ladies and gentlemen, I would argue to you there's nothing hotter than a gunman in a school. That's pretty hot in my book. And we have training, and he said if you have training or you don't, you figure it out. This defendant had training. He even provided the training. He put on the training. The defense would have you ignore all of that, all the things that they say that he did and that he's the low man on the totem pole. No, he's not. He's the top man. He was the police officer for the school district that showed up first. And why do we go back to having school police officers since Columbine? Because on any given day, you can have a monster that makes his way into your school. On any given day. On any given day, they would have you believe that because there was a wreck outside the school, that confused me. I don't hold me responsible because, the wreck's too much, so not my day. They would have you believe that on any given day where we have bailouts in a community, bailouts happen all the time. Even in large urban areas, you have people who outrun the police. But they want you to believe that because there were bailouts on this given day, but don't hold me responsible. Not my day, not my responsibility. They would have you believe that because he wasn't assigned to that particular school on any given day, don't hold me responsible. Not my day, not my responsibility. They would have you believe that because the doors weren't locked, it's not my responsibility. On that given day, the doors weren't locked, so not my day, not my responsibility. On any given day, I only had a pistol. He had a rifle, so it's not my day, it's not my responsibility. And then they would have us tell, the argument is because you had 3 other officers show up who believed that they were being shot at. Don't hold me responsible, because on any given day, if you've got 3 other people that showed up, it's not my day, it's not my responsibility. And what strikes me so much in this case, and something that we believe the evidence has been brought to you that's going on, is the contrast in the training of the schools. If you think about it, since Columbine, the students have been taught, and you heard that, lock the door, lights out, be quiet. We are basically teaching these kids, and the kids in room 11 and room 12 were taught to practice for their impending death. You don't cry and you don't scream. But we're going to teach you what you do when a monster makes his way into the school. We're going to have you rehearse your own death. But yet, we have active shooter training that says to go to the fire that the defendant taught, but we're going to ignore that. Because on any given day, if he says, not my day, we're supposed to just look the other way. And I am sending a message, and I'm sorry if I'm repeating myself, because I want officers to know those days are over. We're not going to continue to teach children to rehearse their own death and not hold them to the training that's mandated by law. That when you hear the gunfire, you go to it. You go to the shots. You stop the dying, and you hold civilians, children, above yourself. You hold them high. They're the highest priority of life. I think it's telling, and Mr. Turner touched this with you about the defendant's statement, and if you're going to get all the evidence to go back in there. He says in that statement, the teacher, she told me, he's over there, she pointed, he's over there, he's wearing all black. I think that statement is very telling, because in that statement he says, on 3 different occasions, I walked over there. I walked to the school. I walked. And you contrast that with Miss Flores, and what is she saying? I ran, and I tell him, we need to get in there. We need to get in there. She's not saying you go, she's saying we. Because in her mind, I believe you can infer that those kids and the protection of those kids are still tantamount to her. And there's no evidence that she had active shooter training. There's no evidence that she taught active shooter training. She was just a teacher. So are we going to continue to hold teachers and students to a higher level of responsibility than we are going to hold police officers for school districts who raise their hand and say, I will be a police officer. Those hallways will be mine. Those children are my people. Those classrooms are my houses. I will protect them. Are we going to continue to do that? No. Because on any given day, you can be like Mr. Salinas and Ms. Torres, who came in and testified to you. They dropped their children off for school that day, and the next time they saw their children, it was at the hospital. Mr. Salinas told you that the child that he dropped off for school that day is not the same child he picked up. Because on any given day, a monster can make his way into an elementary school. Ms. Garcia testified that she dropped her child off for school, she went to the award ceremony, and her daughter wanted to come home with her. And she said, no, I paid $2 for that pizza party, you're going to go and have a good time. And then she never saw her daughter again. Because on any given day, that can happen. We know that. We see it. Nueces County is not any different from Uvalde County. It's just not. What happened to Uvalde on May 24th can happen anywhere at any time. And if it's going to happen, and if we have laws mandating what the responsibility of a law enforcement peace officer is for a school district, then we better be ready to back it up. You had the teachers come testify to you about what was going on. And what do we know about what the defendant had versus the children in rooms 111 and 112? The defendant had his car. It was on the corner building. He had cover. What did the children have? They had chairs and desks. Defendant had a pistol. What did the children have in rooms 111 and 112? They had unarmed teachers. The defendant had a vest on. And what did the children have in rooms 111 and 112? They had curtains to hide behind. I would also, if you get all the evidence back, that you listen to the defendant's statement. And I think it's always telling, is when that ranger asked him, why didn't you engage? Why didn't you go and approach? And the look on the defendant's face is like, not me. Really? I mean, it's like he catches himself. Because it wasn't his day. On any given day that this monster made his way to Robb Elementary, that wasn't his day. You heard a lot about the time compression, the auditory exclusion, the fatal funnel, the OODA loop, the echoing. You even heard about a fatal field. Fatal field. Because we all know on any given day there may be a fatal field. And we have to be ready. You're going to get all the evidence behind you, sent back with you, and you'll have the radio traffic, and you can look at that and decide if it's 1 minute or 3 minutes. But even a minute and 48 seconds, what he put up here, a minute and 48 seconds. I don't know if anybody just sat still for a minute and 48 seconds. That's a very long time to distract, engage, and delay. And his backdrop was right here. Was right here. All he had to do was to even attempt to distract, delay, or engage. I know this case is difficult, and it has been difficult. But we cannot continue to let children die in vain. We cannot. Nueces County is not any different from Uvalde County. We cannot let 19 children die in vain and another 10 to suffer. They're going to be that suffering for a long time. On behalf of those 19 children, I respectfully request that after your deliberations, that you return a verdict of guilty.